Judge, I'll let the court know. Judge, we've been having issues with our internet, so you might lose me a couple times.
You kind of broke up a little bit there in the middle of it.
Now.
But so let us know. Yeah, you're freezing up a lot. Fortunately, most of the conversation is between me and your client. So if something goes wrong, Joe, you're frozen again, it looks like. Let me know. You can always, if you, he's gone. They are having trouble over there, huh? Let's see if he rejoins. Well, that's kind of stupid. I just sent him an email, but I thought about it. If they're having the internet problems, he probably can't get email any better than he can get on Zoom.
Do you want me to call him and tell him anything, Judge?
Let me see. I'm not sure if I have Joe's number here in front of me or not.
I got an email from him yesterday, so I can look it up.
Here he comes.
Oh.
Let's try this again.
Okay. Should we hustle up and try and get it done before something goes wrong
Please,
here?
Judge. If not, I'll try to go on my phone.
Okay. All right. Let's get rolling. We'll be on the record in case number 2020 CR 80, captioned State of Kansas versus Amber Frame. Would the parties announce their appearances, please?
May it please the court, the state appears by and through Thomas Penland.
May it please the court, the defendant appears by and through counsel Joseph Dewaskin. All parties appear by Zoom.
All right. So, Ms. Frame, we're taking up your plea today. And to do that, I'm going to have to ask you a bunch of questions. If I ask you something that you don't understand, tell me that, and we'll talk about it until we make sure we're both on the same page. If at any time you want to talk to Mr. Dewaskin before you answer a question, just let me know that, and I'll give you that opportunity. We'll send you to a breakout room or whatever we need to do so you can talk to him in private, okay?
Okay, great.
All right, to do this, I need to swear you in. So if you would raise your right hand, Ms. Taylor, my court reporter, will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Go ahead and put your hand down. All right. Ms. Frame, how far have you gone in school?
I have some college.
All right. So I take it you read and write okay?
Yes, I do.
All right. Now, as you sit here today, I know you're in custody, but are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing today?
No, I'm not.
Feel like your mind's clear today?
Yes, I do.
All right. Do you know what you're charged with?
Yes, I do.
All right. And you know that you don't have to change your plea from one of not guilty to guilty. You can maintain your not guilty plea. And if you did so, you would have an absolute right to a jury trial in this case. Do you understand that?
Yes, I do.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Dewaskin would help you throughout that trial. He would cross-examine, confront all of the state's witnesses, challenge all of their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand all that?
Yes, I do.
At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Mr. Penland here couldn't argue to the jury, well, you must be guilty because you didn't tell them your side. You understand that?
Yes, I do.
All right. If we went through that whole trial and at the end of that trial, there was a conviction, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, I do.
All right. Now, if we go forward and take this plea today, you're going to be giving up all of those rights. There's not going to be a trial of any kind in this case. You understand that?
Yes, I do.
All right. I want to share with you now what Mr. Dwoskin sent to me as the plea petition. And I'll ask you first, can you see that document?
Yes, I can.
All right. And do you recognize it?
Yes, I do.
All right. Is that the plea petition Mr. Dwoskin went over with you?
Yes, it is.
All right. And there's a signature on it there at the end where it says defendant. Did you place that signature there?
Yes, I did.
Feel like you understood everything in the document?
Yes, I understand it.
Okay. Part of this document is what's called the recitation of the plea agreement. It's rather lengthy, but I'm going to go through it with you right now. It says that you're going to be pleading guilty to count 1 and count 5 of the information, that the state's going to dismiss all of the rest of the counts, that both parties are going to recommend to the court that the sentence in count 1 and count 5 run concurrently with one another. The state's going to recommend the standard number in the box that takes into consideration your criminal history and your crimes of conviction for a sentence. You're agreeing to pay restitution to all of the victims, even on the dismissed counts, as long as the state can provide that number before the sentencing date. The statutory fine is you will agree to pay. We believe it's going to be $500. Depends on the requirements of the statute, but I think that's correct.
Okay.
Parties think you're going to fall into a presumptive probation box. The state's not going to oppose your application for probation. That you know that the state is only bound by this agreement if you appear at sentencing and don't commit any new crimes before that sentencing. Is that your understanding of the entire plea agreement?
Yes, it is.
All right. Mr. Dwoskin fell out again, it looks like. Let's see. If he's trying to get back in. I'm going to stop this share for a second so I can see. All right. I think we just need to kind of pause until we can get Mr. Dwoskin back. And we'll see where we get to. Here he comes. All right.
Sorry,
Mr. Dwoskin, I had finished going over the terms of the plea agreement, basically reading it out of that plea agreement. And then we paused when I realized that you weren't here longer. So let me share this again. All right. And I guess I asked you this, but Ms. Frame, let me ask you again. Is that your understanding of the entire plea agreement?
Yes, it is.
Has anybody else promised you anything other than what I just read to you to get you to plead guilty today?
No, they have not.
All right. And has anybody placed any force or threats against you to make you plead guilty?
No, they have not.
All right. Mr. Penland, Mr. Dewaskin, do you have an idea of what the defendant's criminal history will be?
I do not, Judge.
Judge, I believe that I did. Now I forgot. I think she's going to be an E.
Okay. All right. So, Ms. Frame, I'm sure Mr. Dewaskin's talked to you about the sentencing guidelines and where you would fall in given the level of these crimes in your criminal history. You understand he's using the information that he has and that you've given him to kind of determine where he thinks you fall on that grid, but that won't be official until there's a pre-sentence investigation that is accepted that sets out your actual criminal history. You understand that?
Yes, I do.
So if that turns out to be higher than you or Mr. Dewaskin thought, that could subject you to a higher sentence than you and he may have talked about. You understand that?
Yes, I do.
Okay. So given that, what I have to do today is just assume you have the very worst criminal history so I can advise you what the maximum that anybody can get in this case is, okay?
Okay.
So for count one, the maximum would be 30 months in prison and a post-release supervision duration of 12 months. For count five, it would be, is that added 1 and 5 is an I, Mr. Dewaskin?
Yes, Your Honor.
Okay, so
That's how he
that's
did
he combined the two of them together for that. And the maximum fine on this case would be $100,000, but there's a statutory minimum of 500. Do you understand those are the maximums in this case?
Yes, I do.
All right. Looks like oh, no, there's Joe again. All right. Do you have any questions, Ms. Frame, about anything that we've gone over today?
No, I do not.
All right. Mr. Dewaskin, do you know any legal reason why your client should not plead guilty today?
No, Your Honor.
All right. Then, Ms. Frame, I will ask you, as to count one of the information which charges you with forgery, which is a severity level 8 non-person felony, how do you plead, guilty or not guilty?
I plead guilty.
As to count 5, the charge of theft by deception, which is a severity level 9 non-person felony, how do you plead, guilty or not guilty?
Guilty.
All right. Now, Ms. Frame, I'm going to ask the prosecutor to tell me what he thinks the evidence would be if we had a trial in this case. I want you to listen closely because when we're done, I'm going to ask you if that's what happened, okay?
Okay.
Mr. Penland.
Yes, Judge. Back on March 7th of 2019, the defendant presented a check to Kansas City Fairfax Credit Union at their location at 104 Sunshine Road, which is here in Wyandotte County, Kansas. That check amount was for $842.38, drawn on a business entitled Rick the Plumber, and purportedly made out to Amber Frame. That check was endorsed incorrectly. It was the owner of that business had no knowledge and did not intend to issue a check to Amber in her name. That would be the evidence for count 1. So that check was forged. And for count 5, there were a string of events where she was doing the same thing, presenting false checks that were forged to the bank and getting money from the bank and keeping it, which would support the count of theft by deception, and it did amount to over $1,500.
All right. Ms. Frame, you heard what the prosecutor had to say?
Yes.
Is that what happened?
Yes, it is.
All right. I will find the defendant has freely, voluntarily, and intelligently entered into her plea of guilty. She understands the nature of the charges and the consequences of the plea. There is a factual basis for a finding of guilt, and I will in fact find her guilty of counts 1 and 5 of the information. Per the plea agreement, the other charges are dismissed. I will order a pre-sentence investigation be conducted, and we're going to set this sentencing. Let me take a look. We're probably not going to get to it till after the end of the year. So how about January 8th at 9 o'clock?
Judge, that I will not be available on that day.
January 15th at 9 o'clock.
That works for me, Judge.
All right. And Mr. Penland as well?
Yes, Judge.
Okay, that's when I'm going to set the sentencing. Is there a reason why Ms. Frame should remain in custody pending sentencing?
No, Judge.
Judge, and I was actually going to ask if the court would release her on an OR so she can smell things taken care of.
All right. Ms. Frame, do you have any holds anywhere?
I do. It is at book and release status right now, and I am to report to the center, the Adult Residential Center, and that can be done before sentencing in Wyandotte.
It cannot be done.
It can. It
Oh, it
will
can.
be done.
Okay.
Yes.
All right.
And
So
the center will make sure. I am sorry, Your Honor.
that's
the-
okay.
The center has transportation for me to make sure that I do arrive at my sentencing date in court.
All right. So I'm going to go ahead and issue an OR bond and release Ms. Frame today. Mr. Dwoskin, have you done a PSI request yet?
I have not, Your Honor.
Okay, when
I
we're
will.
done here, I'm going to let you and Ms. Frame talk for a bit and get that filled out. I would assume that you'll want to use the Johnson County Residential Center as her contact information so that they can reach her there to set up whatever she needs to do for her PSI.
Okay, Judge.
All right,
Thank you.
so we're set for sentencing January 15th at 9 o'clock in the morning. Ms. Frame, I'm going to sign a release for you today. And then my guess is Johnson County will take you out, take you to the residential center. Mr. Dwoskin's going to go over this form that he needs to submit to probation. It's going to have contact information so that the probation office knows how to get a hold of you to set up whatever they need to set up, okay?
Okay, thank you, Your Honor.
All right, anything else for our record today?
No, Judge.
No, Judge.
Joe, this is what we're adjourned. This is what I'm going to do. I'm going to leave and I'm going to make you the host so that we can all leave. You can talk to Ms. Frame, and then when you're done, just end the meeting.
Okay, thank you. Thank you, Judge. And Ms. Frame, if we wind up having issues, I'll just call you at the